You to Lawminds YouTube channel. Today we're diving into the fascinating world of dispute resolution methods that are arbitration, conciliation, and mediation. Buckle up for something amazing, and you might get to know some amazing facts that you might have never known before. So, before we dive into arbitration, conciliation, and mediation specifically, we should know what exactly are they a part of. Alternate dispute resolution, the process by which disputes between the parties are settled or brought to an amicable result without the intervention of a judicial institution and without any trial, is known as alternate dispute resolution. It has been very rightly stated that justice delayed is justice denied. And it has been very rightly stated by the Supreme Court, that is the Apex Court, in the Husainara Khatun versus State of Bihar case, that right to speedy trial is an implicit part of Article 21. So, what exactly is alternate dispute resolution? Alternate dispute resolution is a mechanism of dispute resolution that is non adversarial, that means working together cooperatively to reach the best resolution for everyone. It is aimed at dispute settlement outside the court. It offers to resolve different types of matters, which include civil, commercial, industrial, family, etc. It is instrumental in reaching and reducing the burden of litigation on courts while delivering a well rounded and satisfying experience for the parties involved. It provides the opportunity to expand the pie through creative collaborative bargaining and fulfills the interests driving their demands. So, now we'll specifically dive into arbitration. What exactly do we understand by arbitration? It is a very popular alternative to traditional litigation. Arbitration is a dispute settlement method where dispute is submitted to an arbitral tribunal. The decision that the arbitral tribunal gives is called an award and it is binding on the parties. It is less formal than a trial, but the rules of evidence are often relaxed. There is no right to appeal on an arbitrator's decision, except for some interim measures. There is a very little scope for judicial intervention in this arbitral procedure. Now, let us get to know some important features of arbitration. The first and foremost being confidentiality and privacy. The proceedings takes place in such a manner that the confidentiality of the matter is not compromised. The information that gets out in the arbitral tribunal stays there and cannot be used in the court itself as an evidence. The time and cost efficiency. Obviously, the main motive behind alternate dispute resolution is to cut the time and the cost that goes into the traditional litigation. The decision making power rests with the arbitral tribunal, as the award that is given by the arbitral tribunal is binding. Now, let us go forward with some interesting facts. Did you know that ancient Greeks and Roman civilizations utilized this method to settle dispute resolutions involving commerce and trade? Did you know that arbitration has been used for centuries and it is not a new concept, not for India and neither for the rest of the world? Further, here's another mind blowing fact: you can arbitrate just about anything. From business contracts to sports disputes, arbitration is a widely employed in every field. Plus, it is confidential, meaning that the details of proceedings remain private, unlike court trials. Further, some arbitrations have their own specific rules. The International Chamber of Commerce has its own ICC arbitration rules, and the American Arbitration Association has its AAA commercial arbitration rules. Now that we know some of the most important and interesting facts about arbitration, we shall move forward to conciliation. What exactly is conciliation? Now, you might get confused, or you might have been confused about the difference between arbitration, conciliation, and mediation. But I assure you, by the end of this video, you would be able to distinguish between each of them along with their features, and you might as well remember the important and new facts that I have bring into light. Also, you would also be able to understand which particular type of method can be applied in a particular case. Moving forward with conciliation. Conciliation is a non binding procedure. An impartial third party conciliator assists the parties to a dispute in reaching a mutually satisfactory agreed settlement of the dispute. It is less formal than arbitration itself and does not require an assistance of any prior agreement. In arbitration, there has been a requisite demand or a requisite essential, that is that there should be an arbitration clause in the agreement and there should be a valid agreement into formation before going forward with arbitration, but that is not the case with conciliation. You do not require an agreement where you have stated that okay, the parties would go forward with conciliation in case there is a dispute that arrives. Further, parties are free to either accept or reject the recommendation of the conciliator. Whenever the conciliator gives out some recommendations, it's up to the parties to either accept them or deny them according to their interests. If both the parties accept the settlement, then it shall be final and binding. How come it becomes final and binding? They form an agreement, and that is how the conciliation comes into an end. Some of the features of conciliation are it is private and confidential. All the dispute resolution methods have one common feature, that is, they are private and confidential. The information that gets out during the arbitral proceedings or conciliation proceedings would not be used as evidence in other trials. Secondly, it is a flexible procedure. Thirdly, it is speedy and less expensive. Conciliation has been used as an art of persuasion because the mediator's primary role is to guide the parties towards a mutually acceptable resolution. Further, let's get to know some of the most interesting and important facts about conciliation. A lesser known but powerful method of dispute resolution, conciliation. Did you know that conciliation is often used as a diplomatic tool? It has been often used as a diplomatic tool to prevent conflicts between countries. Conciliation is not only used as a domestic practice, it has been used by various countries in order to avoid certain conflicts and avoid disputes between the countries themselves. Further, here's another interesting fact. In some countries, conciliation is deeply ingrained. Take the Pacific Islands custom system, where community elders facilitate conciliation process, bringing people together to resolve disputes amicably. Thirdly, did you know that conciliation can save relationships? Unlike adversarial approaches, conciliation fosters cooperation and understanding, preserving valuable connections. Now we would be going forward with mediation. We have already discussed conciliation and arbitration. Now we are moving forward with mediation. What exactly is mediation? Mediation is a process in which an impartial third person, that is, a mediator, helps parties reach a mutually acceptable resolution of the dispute. Mediators do not decide but help the parties to communicate so that they can try to settle the dispute themselves. The mediation process leaves control of the outcome within the parties. We have observed that in conciliation, what exactly does the conciliator do? He recommends certain solutions, but it is quite different when it comes to mediation. The mediator does not recommend, but it helps the parties to communicate and reach a solution by themselves. The dispute may involve states, organizations, communities, individuals, or any other representatives with a vested interest in the outcome as parties. Now, that is another interesting fact about mediation, that even mediation is not just in domestic practice. It has been used in international platforms as well. Now, let us look at some of the features of mediation. One of the first features of mediation is neutral third party, that the third party that acts as a mediator is neutral. It is not inclined to either of the the parties involved in the dispute. And before starting with the mediation, they make this very clear through their opening statement that they're not inclined to either of the parties, neither do they have any interest in either of those parties. Next, we have conducive environment for open communication. It is the job of the mediator to create an environment just so that the people who are there, the parties that are the parties to the conflict, can communicate, and they are free. They are mentally free to talk and to create an environment which is open for communication. Thirdly, parties retain control over the outcome. Here, as the mediator is not really suggesting anything, or he's not giving out an award like an arbitrator, right? So the parties jump to a conclusion by their own selves, by coming to an understanding between the parties themselves. Hence, the parties retain the control. Now, let us look into some of the amazing facts about mediation. Here's a mind blogging fact: mediation can be transformative. It is not just about reaching an agreement, it empowers parties to understand each other's perspectives and find a win win solution. Did you know that the mediation Did you know that the mediation's origins can be traced back to ancient Indians' religious practices? Thirdly, let us look at another fact, that is what method should be chosen for a particular conflict. Now, there is no hard and fast rule. The only important fact that has to be noticed here is that in a particular method, that is arbitration, you require an agreement that has been formed prior to the dispute taking place. Other than that, when you go for conciliation or mediation, you can go according to the needs of the parties or according to the situation and the facts at hand. The only requirement that is prerequisite for one to go for arbitration is a formation of an agreement prior to the dispute. Hence, we have very beautifully experienced what exactly arbitration, conciliation, and mediation are. We also dived into some of the most interesting facts about all three of them. Hence, we conclude this video with this particular understanding of ours about arbitration, mediation, and conciliation. Hope you enjoyed the video, and if you did, please subscribe to Law Minds. Further, if you have any queries or doubts, you can comment in the comment section. Please like and share, and you can also visit the Law Minds website for further information in regards to case briefings, articles, and internships. Thank you.